Laws of agency, property ownership and land use controls and regulations must 5 out 27 A and B take title together at the same time under the same deed, each owning one half of the real property. What form of co-ownership will law presume they have? Correct answer: tenancy in common. Rationale to have joint with right of survivorship. Joint tenancy in common, all four unities must be present: possession, interest, time, and title. Right of survivorship also must apply. Estate by the entireties is a form of co-ownership between husband and wife with right of survivorship, but has been abolished in most states because the question did not specify whether A and B have the right of survivorship or not. The law presumes tenancy in common. Which of the following is not appurtenant to real property? Correct answer: outbuildings. Rationale: outbuildings do not automatically stay with the land. A deed of trust is a mortgage in some states, and is appurtenant to the ownership unless steps are taken to remove it from the title. Easements and mineral rights run with the land. Special restrictions to all properties within a subdivision would be found in. Correct answer: record of restrictions. Rationale: a mortgage contains only the terms between the bank and the borrower. The corporate minutes of developers are not public records. Subdivision records are not necessarily public records either, but the records of restrictions are found on the deeds to all properties within a subdivision and on the master plat record. Which of the following is considered real property? Correct answer: light fixtures. Rationale: light fixtures are considered part of the home and thus part of the real property. Tenants' fixtures are allowed to be removed by a tenant prior to the expiration of the lease. Implements are tenants' crops which the tenants are allowed to remove, and an area rug is not the same as tacked down wall-to-wall carpeting. Fixtures and showcases attached in a store that occupies rented space are considered. Correct answer: all of the above. Rationale: trade fixtures are fixtures that can be removed at any time and are considered personal property, or chattels, of the tenant. Laws of agency, missed 4 out of 18. In real estate transactions, a real estate salesperson has a direct fiduciary relationship to. Correct answer: the sponsoring broker. Rationale: while the salesperson has a fiduciary duty to the broker's client, direct fiduciary duty is owed to the sponsoring broker. A seller lists her house with Happy Days Realty. A buyer is shown the listing by an agent with Sellmore Homes Realty. Who must the buyer's agent represent? Correct answer: Sellmore Homes Realty. Rationale: an agent must first represent her broker, and on behalf of the broker be a good fiduciary to the broker's client. Which of the following is the best example of a general agent? Correct answer: a property manager. Rationale: a universal agent is one who may do anything for the principal, while a general agent may do anything in one specific area, like property management. A real estate agent is considered a special agent, having the authority to do only one thing for the principal, just like the person given the power of attorney to transfer an automobile. When counseling seller clients, an agent should do all of the following except. Correct answer: prepare a market analysis that shows a high price for the property, because one never can tell what a buyer might pay. Rationale: agents must be careful to study all factors influencing value. For some sellers, time on market is more critical than price. A market analysis should always reflect the most realistic situation. Valuation and market analysis missed 8 out of 18. What is market price? Correct answer: the price the property actually sold for. Rationale: market value is what the property is likely to bring. Insurance value deals with the cost of replacement. A 10-unit apartment building has a net income of $5,000 annually per unit. If the purchasers wish a 10% return on their investment, how much should they be willing to pay for the property? Correct answer: $500,000. Rationale: $500,000. The value of the property equals net income / rate of return. Thus value equals $50,000, $5,000 per unit x 10 units, 0.10 equals $500,000. The subject property best describes. Correct answer: the property for which the value is sought. Rationale: the appraiser does not consider properties on the market. The subject is the property for which an opinion of value is sought, also called the base. When underwriting a loan application, a mortgage company is usually interested in which of these values? Correct answer: market value. Rationale: the mortgage company needs to establish market value, so it knows the LTV position it is in. The 3 most important aspects of a house are. Correct answer: location, location, location. Rationale: where the property is located alone can contribute value to the property regardless of size, style, or function. A home with a basement wall that is failing is best described as suffering. Correct answer. Incurable physical deterioration. Rationale. Major structural problems usually cannot be fixed at any cost that makes economic sense, hence this is incurable physical deterioration. For the income approach to appraisal, debt service refers to what? Correct answer. Mortgage payments. Rationale. Anything related to the financing of the investment is debt service and cannot be counted as an expense. Reproducing a structure best describes. Correct answer. Building an exact replica of the structure. Rationale. Building an exact replica means that the replica has the exact look and feel as the original structure. If a historical building were destroyed, the building would likely be reproduced. Financing. Missed 8 out of 20. The deed of trust is considered to be. Correct answer. Security for the debt. Rationale. The deed of trust allows the lender, in case of loan default, to order the trustee to sell the property. Thus, the deed of trust is security for the debt. You have written an offer in which the buyer asked the sellers to pay his half of the escrow fee and his 3 points. The sellers accepted $135,000 for the home and the buyer is going to put $40,000 down. How much will the buyer pay for his points? Correct answer. Nothing. Rationale. Read carefully. The sellers, not the buyer, are paying the points. Miss Kelly sold her property herself and has agreed to finance the property. According to Truth in Lending, Ms. Kelly must reveal. Correct answer. Nothing. Rationale. The seller in a purchase money mortgage is not bound by Truth in Lending laws, which require APR, finance fees, and discount points from lenders only. A viable alternative to foreclosure would be. Correct answer. A deed in lieu of foreclosure. Rationale. A deed in lieu of foreclosure is given by the homeowner to the bank in lieu of foreclosure. The attachment is filed with the sheriff's office to attach real estate prior to foreclosure. A writ of execution is filed with the sheriff, authorizing him to seize the property at the time of foreclosure. Lis pendens literally translated means lien or litigation pending, and is filed against the homeowner. John is a successful bidder at a sheriff's foreclosure sale. At the sale he receives a certificate of sale, but does not know what it means. John's lawyer explains. Correct answer. That he is entitled to a deed upon confirmation of sale by the court if the land is not redeemed by the original owner during the redemption period. Rationale. A certificate of sale is issued to a buyer at a judicial sale, foreclosure action, entitling the buyer to a confirmation of sale by the court if the land is not redeemed during the redemption period. The attorney's opinion of ownership is termed a certificate of title. A certificate of no defense is issued by a bank to state how much principal is still owed on a mortgage. It is not issued by an attorney, but as an estoppel certificate from the lender. Mortgages are recorded to. Correct answer. Create a valid lien. Rationale. A mortgage is not a lien until it has been recorded. It still may be binding between the bank and the purchaser, but it would not create a lien on the property. Therefore, subsequent purchasers could not be held to have knowledge of the mortgage. The Truth in Lending Act requires that the buyer be given a good faith estimate of the cost of interest, loan payments, etc., and does not require that the mortgage be recorded. The obligation or promise to be personally liable for conditions in another person's contract is known as. Correct answer. Assumption. Rationale. The giving of one person's rights under contract to another is assignment. The promise to be liable for another person's obligations under contract is assumption, that is loan assumption. The seller assigns the loan while the buyer assumes the loan. Disintermediation refers to. Correct answer. The movement of money out of a savings account into a higher yield investment such as a corporate or government instrument. Rationale. A deed of trust is an instrument used in many states in place of a mortgage. Dedication is the transfer of real property by a private owner to a public agency. Disintermediation is the movement of money out of a savings account into a higher yield investment such as corporate or government instruments. Transfer of property. Missed 3 out of 13. Who prepares the tax bill? Correct answer. The tax collector. Rationale. The tax bill, which assesses land and improvements separately but taxes them at one rate, is prepared by the tax collector. A couple is divorcing. The husband is ordered to convey his interest to the wife. When must she receive the transfer disclosure statement? Correct answer. It is not required. Rationale. A divorcing couple is an exception to the transfer disclosure law. What is the purpose of the assessment roll? Correct answer. To establish the tax base rationale, county tax assessors assess the value of all taxable property in the county every year. The annual assessments are then published in the assessment roll. Its purpose is to establish the tax base. Practice of real estate and mandated disclosures miss 9 out of 36. How much can be paid on behalf of the licensee out of the Real Estate Recovery Fund per licensee? Correct answer: $250,000. Rationale: although the fund can only pay $50,000 per transaction, it can pay up to $250,000 per licensee. Alfred and Allie buy a 10-year-old home and have it tested for radon prior to closing. The test results in an average reading of 4.8 pL. Under federal law, is the seller required to mitigate the home? Correct answer: no, unless agreed upon in the contract between buyer and seller. Rationale: there is no federal law regarding radon mitigation. The federal government recommends mitigation on houses that test 4.0 pL or higher. However, the buyer and seller, in their contract, could agree to whatever guideline they wish. During the sale of a property, who would an agent and client negotiate with? Correct answer: customers. Rationale: the broker and the principal negotiate with third parties, also known as customers. All of the following people need a license to practice real estate except, correct answer, any trustee selling under a deed of trust. Rationale: as a rule, any negotiating or soliciting for a fee requires a license. A real estate broker presented an offer to a seller from a financially qualified buyer. Unbeknown to the seller, the buyer is the broker's sibling. This fact was not discovered until a week before closing. What option exists to the seller? Correct answer: cancel the transaction with no liability to the broker. Rationale: the broker must disclose the material relationship between himself, herself and the sibling. If not, the seller can cancel the transaction and not owe the broker any commission. Any employee who is authorized by broker to make withdrawals from the trust account must be, correct answer, fidelity bonded. Rationale: any employee who is authorized by a broker to make withdrawals from the trust account must be fidelity bonded in order to make withdrawals. The laws that affect the licensing and conduct of real estate agents are called, correct answer, real estate law. Rationale: real property law deals with land and its ownership. Real estate law deals with agents and their conduct. How long does a landlord have to return the unused portion of a tenant's security deposit? Correct answer: 21 days. Rationale: a landlord must return the unused portion of a security deposit within 21 days of termination. Which of the following is a violation of the California Code of Ethics and Professional Conduct? Correct answer: telling a seller her home is worth more than it is, in order to get the listing. Rationale: the Code of Ethics and Professional Conduct prohibits agents from telling sellers their homes are worth more to get the listing, or telling buyers a home is worth less, to induce them to make an offer. Contracts miss 2 out of 18. What would automatically terminate an offer? Correct answer: counteroffer. Rationale: a counteroffer automatically terminates the original offer and creates a new offer. Seller: Joe's agent personally delivered Mary's offer to buy Joe's house. Joe said he would like to think about it for a couple of days. Later that week, without making a single change in the contract, Joe decided to accept Mary's offer and signed it. Then he addressed it to Mary and went to the post office and mailed it. Is the contract binding on both parties? Correct answer: yes, because Joe sent it to Mary in the mail. Rationale: the mailbox rule says that when an acceptance isn't communicated directly, either in person or over the telephone, it's effective as soon as it is placed in the U.S. mail to the offeror, even though the offeror hasn't received it yet. The mailbox rule applies only to acceptances, not to revocations. Revocations are not effective until they are actually received by the offeree. March 4, 2023. Who is responsible for determining whether or not a property is located in an officially mapped natural hazard zone? Buyer's agent. Incorrect. Seller and seller's agent. Correct. Public official. Buyer. What is seller and seller's agent? Question. Rationale: the seller and listing agent are responsible for determining if a property is in an officially mapped natural hazard zone. Seller S, listed with broker L, sells her home to buyer B for $200,000. Buyer B is represented by his own buyer's agent. An earnest money check for $2,000 is attached to the contract. After both parties have fully executed the contract, broker L deposits the check into his escrow account, per the contract instructions. 2 days later, L receives notice that the check is being returned for insufficient funds. What should L do first? Cover the check out of his own funds and then contact B to repay him. Contact B immediately to get the check covered. Contact S immediately and notify her of the bad check. Correct. Contact the buyer's agent immediately to get a new check. Incorrect. What is contact the buyer's agent immediately to get a new check? Question rationale. Although L will probably need to contact several people, the first call should be to his client, seller, as he owes her the duty of full disclosure. A bad check could possibly nullify the transaction. Which of the following is not grounds for revocation or suspension of a license? Violation of the Code of Ethics. Correct. Violation of the Civil Rights Act of 1866. Violation of the Canons of Ethics. Incorrect. Violation of the Federal Fair Housing Act. What is violation of the Code of Ethics? Question rationale. The Code of Ethics is a set of voluntary rules of conduct established by the National Association of Realtors. The Federal Fair Housing Act and the Civil Rights Act of 1866 are both federal statutes, and the Canons of Ethics list the ethics laws of individual states. Which act prohibits discrimination by businesses? Under Civil Rights Act. Correct. The Holden Act, Rumford Act, Class Act. What is under Civil Rights Act? Question rationale. The under Civil Rights Act prohibits discrimination by businesses. In the 1968 landmark U.S. Supreme Court case of Jones v. Meyer, it was ruled that racial discrimination in the sale of any property is prohibited, without exceptions. Correct. The Fair Housing Act is void. Sexual preference is now a protected class in fair housing laws. State law shall take precedence over the Federal Fair Housing Act. What is racial discrimination in the sale of any property is prohibited without exceptions. Question rationale. The Jones v. Meyer case interpreted the Civil Rights Act of 1866, not the Federal Fair Housing Act of 1968. The Supreme Court found that when it comes to racial discrimination in the rental, sale of housing and personal property, there are no exceptions or exemptions to the 1866 law, even though there were 4 exceptions in the 1968 Act. Statements not known to be untrue at the time they are made are called actual fraud. Innocent misrepresentation. Correct. Fraudulent misrepresentation. Negligent misrepresentation. Incorrect. What is innocent misrepresentation? Question rationale. Innocent misrepresentations are statements not known to be untrue at the time they are made. An agent is usually not liable, although the buyer or seller could cancel a contract over it. If an investigation determines a violation of the Rumford Act, an owner can be made to do all of the following except: the owner must complete the rental or sale. The owner must pay up to $1,000 in damages. The owner must convey title to the victim. Correct. The complainant is entitled to the next available unit. Incorrect. What is the complainant is entitled to the next available unit? Question rationale. The owner must pay damages, offer the next available unit, or complete the sale. Who appoints the Real Estate Advisory Commission? The Real Estate Commissioner. Correct. Director of Commerce, Public Election, the Governor. Incorrect. What is the Real Estate Commissioner? Question rationale. The Governor appoints the Real Estate Commissioner. Who appoints the Real Estate Advisory Commission? The commission consists of 6 brokers and 4 members of the public. When the seller asks the broker to keep a latent defect to herself, the broker refuses. What code contains the ethical guidelines for the broker? Civil Code, Criminal Code, NAR Code of Ethics. Incorrect. Business and Professions Code. Correct. What is Business and Professions Code? Question rationale. A broker would rely on the Business and Professions Code of Ethics. 2 brokers get together at a breakfast meeting and decide they will each agree to work in certain geographical areas of the town. Which of the following statutes have been violated? Equal Credit Opportunity Act, Civil Rights Law, Federal Housing Antitrust Law, Sherman Antitrust Act. Correct. What is Sherman Antitrust Act? Question rationale. The Sherman Antitrust Act prohibits monopolization, price fixing and market fixing. Would be 2 examples of a violation of the Sherman Antitrust Act. While walking through a home, a buyer notices a large crack in the wall. The seller does not disclose this item on any property disclosure statement. After the sale is completed, the buyer sues the seller for the necessary repairs of the crack in the wall. The buyer has no claim, under the doctrine of caveat emptor. Correct. The seller is liable for failing to note the crack on the applicable property disclosure form. Incorrect. A seller is never liable for repair defects after the closing. The seller is liable to make the repairs. What is the buyer has no claim, under the doctrine of caveat emptor? Question rationale. Under the doctrine of caveat emptor, let the buyer beware. The buyer must examine goods or property and buy at his own risk. Any patent defect does not need to be disclosed by the seller, as it is readily viewable by the buyer and the buyer takes the property subject to the defect. A latent defect needs to be disclosed by the seller either directly to the buyer or on the property disclosure form. As this is a patent defect, there is no liability on behalf of the seller. Where would one file a complaint based on the Rumford Act? OEO, in EECP, Department of Fair Employment and Housing. Correct. ECHA. Incorrect. What is Department of Fair Employment and Housing? Question rationale. A complaint based on the Rumford Act can be filed with the Department of Fair Employment and Housing. Potential buyers believe they have been discriminated against because of their race. What option is available to the buyers under the Federal Fair Housing Act? File a lawsuit within 2 years and complain to the Office of Equal Opportunity, HUD, within 1 year. Correct. File a complaint with the Federal Trade Commission. File a lawsuit within 2 years. Complain to the Office of Equal Opportunity, HUD, within 1 year. Incorrect. What is file a lawsuit within 2 years and complain to the Office of Equal Opportunity, HUD, within 1 year? Question rationale. Under the Federal Fair Housing Act, victims have the right either to file a complaint with the Office of Equal Housing Opportunity, HUD, within 1 year of the incident, or to file a lawsuit within the courts within 2 years of the incident. The Federal Trade Commission handles complaints under the Sherman Antitrust Act. April 24, 2023. Examsim, Property Ownership and Land Use Controls and Regulations. 27,22,5. 81%. 3. Which is not an example of common area in a condominium? Correct answer. Balcony. Rationale. Owned by all but used by one owner only is known as limited common area. A laundromat, swimming pool, and the land are owned and used by all owners. This is common area. The balcony is limited to only one person's use. 4. One of the appurtenances to a parcel of land would be, correct answer, bundle of rights. Rationale. The bundle of rights are legal rights conferred to owners of real property, including the right to mortgage, sell, lease, improve, enjoy, and use the property. They run with the land, and thus are pertinent to it. A bill of sale is an instrument in writing that transfers ownership of tangible personal property, not real property. 11. A tax levy on real property for government improvements, that is curbs, sewers and sidewalks, is known as, correct answer, special assessment tax. Rationale. The ad valorem tax is a tax based upon the value of the property. Taxes for improvements to property are called special assessments. The ad valorem tax is the tax that is always paid first. 22. A term used to describe the physical attachment of a fixture to real property, thereby causing it to become a part of the real property, is, correct answer, actual annexation. Rationale. The doctrine of embezzlement refers to crops yet to be harvested from leased land. Adverse possession involves the acquisition of title to land through open, notorious and hostile occupancy of another's property. An easement by prescription is obtained in much the same way as adverse possession, but does not transfer title. Actual annexation is when a fixture is attached to real property. 26. A and B take title together at the same time under the same deed, each owning one half of the real property. What form of co-ownership will law presume they have? Correct answer, tenancy in common. Rationale. To have joint with right of survivorship, joint tenancy in common, all four unities must be present: possession, interest, time, and title. Right of survivorship also must apply. Estate by the interees is a form of co-ownership between husband and wife with right of survivorship, but has been abolished in most states. Because the question did not specify whether A and B have the right of survivorship or not, the law presumes tenancy in common. Laws of agency. 18, 16, 2, 89%. 3. As a result of the decision in Easton v. Strasburger, 1984, real estate agents can be held liable for not only for defects they know about, but also, correct answer, defects they should have known about through a reasonable inspection. Rationale. An agent is responsible for defects he or she should know about due to red flags, clues that there is something wrong, that is netting holding a hillside up. 10. How do brokers and clients enter into agency relationships? Correct answer: express contract. Rationale: the agency agreement must be put into words, in writing or spoken to be considered an express agreement. Valuation and market analysis. 18, 15, 3. 83%. 6. All the following describe the inherent conflict between the appraiser and the listing real estate agent except. Correct answer: appraisers generally follow the wishes of the sellers. Rationale: appraisers do not adhere to the wishes of sellers and agents. They must maintain an impartial analysis of the subject property and not be influenced by these types of external factors that do affect the appraisal process. Agents generally estimate the fair market value of what homes may sell for in the near future. 9. A property's area is 100 feet long by 100 feet wide. The property has a deed restriction that requires 10-foot setbacks on each side, a 25-foot setback on the front of the property and a 30-foot rear setback. How much of the property is available for building use? Correct answer: 3,600 square feet. Rationale: this question involves a building site of 100 square foot x 100 square feet, which would be 10,000 total square feet. However, due to the setback lines, side yards etc., there is only a square of 45 by 80 in which to build. 100 feet 10 setbacks, x, 100 feet 30 25 rear and front setbacks, or 80 by 45 equals 3,600 square feet, which can actually be used for building. 16. The rate refers to. Correct answer: the rate of return used by investors. Rationale: the investor can calculate the present value of future income. The formula known as IRV can take 2 out of 3 factors and figure the sum of the third. Financing. 20, 19, 1, 95%. 20. A lender advertises that there are reasonable monthly terms available for the purchase of a home. Which of the following disclosures is necessary? Correct answer: no disclosure is necessary. Rationale: simple statements such as reasonable monthly terms available will not necessitate disclosure under the Truth in Lending Act. However, a disclosure of a particular item, such as the interest rate or the monthly payments, would require full disclosure of all interest-related items. Transfer of property. 13, 0, 100%. Practice of real estate and mandated disclosures. 36, 32. 4, 89%. 4. Which of the following is not an exemption under the Federal Fair Housing Act? Correct answer: a church selling its church grounds with the help of a broker. Rationale: an exemption exists only if the property is for sale by owner. The sale of church property is exempt only if no broker is involved. 18. What would we call a broker who exercises her option to purchase some land? Correct answer: principal. Rationale: when the broker becomes a buyer or seller, he or she is required to disclose that he or she is the principal. 19. A sales agent is instructed by the landlord, client not to show a commercial office property to any women. Which law is violated if the sales agent follows these instructions? Correct answer: none of the above. Rationale: while gender discrimination is prohibited under the Federal Fair Housing Act, this is not housing, but commercial office space. The Sherman Antitrust Act prohibits price fixing or market fixing. The Civil Rights Act of 1866 prohibits discrimination based upon an applicant's race only. 36. A statement made by an agent who honestly believes the inflated statement about the condition of a property it is called. Correct answer: puffing. Rationale: when a buyer believes the agent's puffing to be true, the agent can be held liable for misrepresentation. Contracts. 18. 14, 4, 78%. 2. A makes an offer to buy B's house. B accepts the terms of the offer and evidences his acceptance by signing the offer. Is there a valid real estate purchase contract? Correct answer: no, because the acceptance has not been delivered back to the buyer. Rationale: the acceptance of an offer does not constitute a contract until the acceptance has been communicated or delivered back to the party who made the original offer, in this instance, the buyer. There is no 3-day cooling off period for real estate other than in the application for a loan or in the refinancing of a loan. 10. An offer to purchase which states that the offer will remain open for 72 hours, correct answer, may be withdrawn by the offeror at any time before the offer is accepted. Rationale: an offer is just an offer. It does not become a contract until it is accepted. Thus, even if the offer said it would remain open for 72 hours, It is not binding upon either party as it is not a contract yet. 11. The commercial broker listed a storefront for rent. A tenant was procured. After the lease was signed, the owner refused to pay the listing broker. In order to get his fee, the broker could, correct answer, lien the property. Rationale: the commercial lien law now permits a broker to lien a piece of commercial property if he is under contract and has earned his fee, but the owner refuses to pay. This is not true of residential property. The broker would have to file suit in civil court to get his fees in a residential dispute. 14. An option agreement allows a prospective buyer a period of time to examine property before deciding to complete the contract. Payments are often made for the privilege of making the examination. What usually happens to those payments if the buyer does not buy? Correct answer: whatever the parties decide in the correct answer: whatever the parties decide in the contract. Rationale: option contracts are unilateral purchase and sale agreements. The contract should set forth what the parties, through negotiation, decide about the disposition of the option money, whether or not the option, in its sole discretion, decides to purchase the property. Normally the seller is entitled to option payments as compensation for holding property off the market and may or may not allow the broker to hold the money or collect a fee or commission. In a foreclosure action, the defendant's case can be based on any of the following except: the maker impulsively signed the note. Incapacity, if the maker is a minor or an incompetent. Secret material changes in the note. Forgery, if the maker did not really sign the note. Answer: the maker impulsively signed the note. If a broker exercises her option to purchase some land, she would be considered a principal. Why is next questions tricking me in thinking of personal property? But that the word is real property. Stay alert and focused on the real word. Real property. Which of the following is considered real property? Tenants, fixtures, implements, area rugs, light fixtures. Answer: implements. Fruiticus. The statement signed by the mortgagee which acknowledges that a loan has been paid in full is called what is a satisfaction of mortgage. Satisfaction of mortgage basics. When a mortgage is paid in full, a satisfaction of mortgage document needs to be completed and submitted to clear the title to the property. This releases the lien on the collateral, often the property, used to secure the loan. A takeout loan in real estate financing is: what is a long-term loan to replace a construction loan? Takeout loan is a long-term loan. It is a permanent mortgage loan which a lender agrees to make to a borrower upon completion of improvements on the borrower's land. The proceeds of the loan are used principally to pay off the construction loan, who may make withdrawals from a broker's trust account. What is the broker or a designated other? As long as the person has the broker's authorization, a licensed salesperson or a broker may make withdrawals. Additionally, an unlicensed employee of the firm may also make withdrawals if he or she has a fidelity bond at least equal to the maximum amount to which that person has access. The liquidation of a financial obligation on an installment basis is commonly termed: what is amortization? Amortization is the liquidation of a financial obligation in installments. A husband and wife want to buy a lot for $25,000. They will pay $10,000 cash and the seller will carry back a note and trust deed for the balance. They intend to build a home on the lot in 5 years. When they are ready to look for a lender that will finance their construction plans, the absence of which of the following clauses may cause them difficulties? What is subordination clause? A subordination clause in a mortgage usually says that all original claims on a debt must be paid before any new ones. A subordination clause in a second or third mortgage gives the first mortgage priority. This means that if the house is sold or foreclosed upon, the debt owed under the primary mortgage gets paid off first. When this husband and wife try to build a house, their lender will likely require the seller to include a subordination clause in the agreement for the lot sale. If the lender for that transaction doesn't agree to a subordination clause, the couple may have a hard time getting a loan to build. When loaning money to 2 or more co-borrowers on a single promissory note, the lender would be best advised to increase the security on the note by inserting which of the following phrases after the names of the co-borrowers. What is jointly and severally? If there are multiple debtors on a note, the lender would be advised to put the phrase jointly and severally in the note. In California, one must use another's land openly, notoriously, and continuously for at least 5 years to obtain an easement by prescription. An instrument which protects the insured party against losses resulting from undiscovered defects and encumbrances such as forgery in the record is title insurance. Sherman Antitrust Act prohibits monopolization or attempts to monopolize any part of trade. Real estate instruments, such as deeds, mortgages, leases, easements, and court orders, are recorded in the county in which the property is located to give constructive notice to the world of an interest in a particular parcel of real estate. The purpose of the assessment roll is to determine the tax base for property taxes. In real estate transactions, a real estate salesperson has a direct fiduciary relationship to the sponsoring broker. The rate refers to the rate of return used by investors. The trustor is the borrower who holds equitable title to the property. The neighbor would not be subject to liability under the Federal Fair Housing Act of 1968 in the given scenario. On the California real estate exam, you may be tested on different types of tax exemptions related to real estate, such as 1. Homeowner's exemption. This exemption reduces the taxable value of a primary residence by up to $7,000 for qualified homeowners. 2. Veterans exemption. This exemption is available for veterans who are disabled or over the age of 65, and it can reduce the assessed value of their property by up to $4,000. 3. Senior citizens exemption. This exemption is available to California residents who are over the age of 62. And it can reduce the assessed value of their property by up to $137,000. 4. Disabled persons exemption. This exemption is available to California residents who are totally disabled, and it can reduce the assessed value of their property by up to $150,000. 5. Church property exemption. This exemption is available for properties used exclusively for religious purposes and can reduce the assessed value of the property by up to 100%. It's important to note that tax exemptions can vary by county and may be subject to change. CPMs are designated by the Institute of Real Estate Management, IRM, which is a professional organization for real estate managers. The deed of trust is considered to be a security for the debt. It is a legal instrument used in real estate transactions, particularly in mortgage loans, where it serves as a security interest in the property being mortgaged. The deed of trust is used to provide evidence of the debt and to establish the rights and obligations of the borrower, mortgager, the lender, mortgagee, and the trustee, a neutral third party. It creates a lien on the property, which can be foreclosed upon if the borrower defaults on the loan. While it is related to the conveyance of legal title, the primary purpose of the deed of trust is to secure the debt rather than transferring ownership of the property. The class of individuals protected under the Equal Credit Opportunity Act, ECA, but not under the Federal Fair Housing Act, FFHA, is marital status. The ECA prohibits creditors from discriminating against applicants on the basis of certain protected characteristics when granting credit. These protected characteristics include race, color, religion, national origin, sex, marital status, age, provided the applicant has the capacity to contract, and the receipt of public assistance. Therefore, marital status is specifically protected under the ECA. On the other hand, the FFHA prohibits housing discrimination based on race, color, religion, sex, national origin, familial status, and disability. Marital status is not explicitly included as a protected characteristic under the FFHA. However, it is important to note that some state or local fair housing laws may provide protections for marital status or other characteristics not covered by the federal FFHA. When receiving stock in a cooperative, you typically become a shareholder or member of the cooperative corporation. As a shareholder, you don't receive a deed to a specific unit but rather an ownership interest in the cooperative as a whole. Shareholders have the right to occupy a specific unit within the cooperative building based on the terms outlined in the cooperative's governing documents and bylaws. In contrast, when receiving a deed in a condominium, you become the owner of a specific unit within the condominium development. The deed establishes your individual ownership of the unit, typically along with an undivided interest in the common areas and amenities shared by all unit owners in the condominium. In California, the statute of limitations for an action on a written contract is generally 4 years. The term realtist is typically used by members of the National Association of Real Estate Brokers, NAREB. A tax levy on real property for government improvements such as curbs, sewers, and sidewalks is commonly known as a special assessment. A legal description of a property based upon points of beginnings, distances, directions, and degrees is commonly referred to as a metes and bounds description. This method of describing a property's boundaries involves identifying a starting point, point of beginning, and then describing the property's boundaries by specifying distances, directions, and angles. The description typically includes landmarks, such as physical features or monuments, to provide reference points for the property's boundaries. Meets and bounds descriptions are often used for properties with irregular shapes or in areas where a more precise description is required. The Public Land Survey System, PLSS, or the Rectangular Survey System. Under this system, land is divided into townships, ranges, and sections, forming a grid-like pattern. Each township is typically 6 miles by 6 miles, and it is further divided into 36 sections, each covering approximately 1 square mile. The PLSS is used to describe and locate land parcels in many parts of the United States, particularly in areas that were historically public lands. Lot and block is a method of property description commonly used in subdivisions and urban areas. In this system, properties are identified and described based on their specific lot and block numbers within a recorded plat or subdivision map. A recorded plat or subdivision map is an official document that details the division of a larger tract of land into individual lots or parcels. It is created by a developer or surveyor and is recorded with the appropriate government office, typically the county recorder's office, to establish a legal record of the subdivision. Property ownership and land use controls and regulations. 27 total questions, 26 correct, 1 missed. One of the appurtenances to a parcel of land would be, correct answer, bundle of rights, not easement and gross. Rationale: the bundle of rights are legal rights conferred to owners of real property, including the right to mortgage, sell, lease, improve, enjoy, and use the property. They run with the land, and thus are pertinent to it. A bill of sale is an instrument in writing that transfers ownership of tangible personal property, not real property. Laws of agency. 18 total questions, 16 correct, 2 missed. An agency relationship can be terminated in all of the following ways except, correct answer, except estoppel, not destruction. Rationale: if the property is destroyed, so is the agency agreement. If the parties become incapacitated, the relationship ends by law. We can create relationships by estoppel, but they cannot terminate in this way. Honeycomb, an actress from Hollywood, hires a real estate agent to list the property that was the subject of the estate of Hannah Has Been. When Miss Combe signed the listing agreement, she did so as the administratrix. How did she get that title? Correct answer, she was appointed by the court. Not the will made the appointment. Rationale: in a will, a testator can appoint an executor or executrix if the will did not mention one. The court must appoint an administrator or administratrix. Transfer of property. 13 total questions, 10 correct, 3 missed. A standard policy of title insurance protects the buyer against what? Correct answer, recorded documents, not unrecorded documents. Rationale: standard policy of title insurance protects the buyer against all recorded documents affecting the title. Once a person has gone to the courthouse and reviewed all documents pertaining to the property he intends to buy, he is said to have, correct answer, actual notice, not constructive notice. Rationale: the law holds that everyone has constructive notice, or presumed knowledge, of recorded documents. Once you actually have seen the documents that pertain to ownership of the property, you have actual notice. Caveat emptor refers to let the buyer beware of physical defects in the property and has nothing to do with a title search. Insurance policy premiums are prorated from the date the policy is, correct answer, assigned. Not written. Rationale: if a loan is being assumed, an insurance premium is prorated at the date of the assignment, that is the date of closing. Practice of real estate and mandated disclosures. 36 total questions, 30 correct, 6 missed. How much can be paid on behalf of the licensee out of the Real Estate Recovery Fund per licensee? Correct answer, $250,000. I said $50,000. Rationale: although the fund can only pay $50,000 per transaction, it can pay up to $250,000 per licensee. A salesperson presents a full price offer from a financially qualified black prospect. Later, the salesperson's broker presents a lower offer to the same seller from a white prospect. The seller accepts neither of these contracts but sells to a neighbor, through the same salesperson and broker, who decides to buy the house to prevent the black prospect from purchasing the property next door to him. Which of the following parties would not be subject to liability under the Federal Fair Housing Act of 1968? Correct answer, the white prospect. I said the neighbor. Rationale: no person is allowed to be a party to a plan of discrimination. The neighbor, the salespersons, and the seller were all part and party to a plan of discrimination and thus are subject to liability under the Federal Fair Housing Act of 1968. The white prospect simply submitted an offer, and is not liable. All of the following documents must be approved by the Real Estate Commissioner prior to use except, correct answer, independent contractor agreement. I said mortgage loan disclosure. Rationale documents we execute with clients must be approved by the Department of Real Estate. Documents between brokers and salespeople do not. During the sale of a property, who would an agent and client negotiate with? Correct answer, customers. I said agents. Rationale the broker and the principal negotiate with third parties, also known as customers. When the seller asks the broker to keep a latent defect to herself, the broker refuses. What code contains the ethical guidelines for the broker? Correct answer, Business and Professions Code. I said NAR Code of Ethics. Rationale a broker would rely on the Business and Professions Code of Ethics. Which of the following could a real estate agent lawfully prepare? Correct answer, none of the above. I said least with option. Rationale all of these documents must be prepared by an attorney at law. Contracts 18 total questions 15 correct 3 missed. Seller Sue promised in the sales contract to have an expensive new roof put on the house before closing. At the closing table, when asked about the roof, Sue said she decided not to replace the roof but just to reduce the sales price instead. What can the buyer do about this? Correct answer, either answer. I said refuse to close. Rationale if one party to a contract performs his or her side of the bargain as set forth in the agreement, the other party is required to perform. 2. If one party fails to perform, and the failure is not excused, he or she has breached the contract and the other party is not required to perform. If seller Adams simply decides not to go through with the closing on a sale to buyer Williams, what can Williams do about it? Correct answer, sue for specific performance and for damages. I said nothing, because the deal has not yet closed. Rationale a successful lawsuit for specific performance may compel Adams to perform his responsibilities under the contract, including transferring title to Williams. In addition, if Williams can prove other damages due to Adams' refusal to perform, Williams may also sue to recover those damages. If the contract was executed, completed, Williams had obtained equitable title, and it would not matter that closing had not occurred. A lease executed by a minor lessor is, correct answer, voidable by the landlord only. I said void. Rationale the minor is the landlord in this question. A lessor is the person who gives the lease. The lease is voidable by the minor landlord, who lacks contractual capacity. Void means the contract never existed. The voidable contract is enforceable only as long as the minor so chooses. May 22, 2023 compucram examsim number 3. All of the following documents must be approved by the Real Estate Commissioner prior to use except, independent contractor agreement, purchase agreements, advance fee contract, mortgage disclosure. Among the documents you mentioned, the one that does not typically require approval by the Real Estate Commissioner prior to use is the Independent Contractor Agreement. While independent contractor agreements are important legal documents used in various industries, including real estate, they are generally not subject to approval by regulatory authorities such as the Real Estate Commissioner. On the other hand, the Real Estate Commissioning may require approval for documents such as purchase agreements, advance fee contracts, and mortgage disclosures. These types of documents are closely related to real estate transactions and often involve consumer protection considerations, which may require regulatory oversight and approval to ensure compliance with applicable laws and regulations. To calculate how much the buyer will pay for his points, we first need to determine the loan amount. The purchase price of the home is $135,000, and the buyer is putting $40,000 down. Therefore, the loan amount will be the difference between the purchase price and the down payment. Loan amount equals purchase price, down payment loan amount equals $135,000, $40,000 loan amount equals $95,000. Now, let's calculate the points. Points are typically expressed as a percentage of the loan amount. If the buyer is paying 3 points, it means they are paying 3% of the loan amount. Points equals loan amount points percentage points equals $95,000 3% points equals $95,000 times 0.03 points equals $2,850. Therefore, the buyer will pay $2,850 for his points. To calculate the amount of discount points the borrower would be required to pay, we need to determine the loan amount and then apply the points percentage. Given, purchase price of the home, $100,000 mortgage percentage, 80% first. We calculate the loan amount by multiplying the purchase price by the mortgage percentage. Loan amount equals purchase price mortgage percentage. Loan amount equals $100,000. 80% equals $80,000. Next, we calculate the discount points. Discount points are typically expressed as a percentage of the loan amount. If the lender charges 3 discount points, it means the borrower would be required to pay 3% of the loan amount as discount points. Discount points equals loan amount points percentage. Discount points equals $80,000. 3% equals $2,400. Therefore, the borrower would be required to pay $2,400 in discount points. Which of the following is not a protected class under the 1968 Federal Fair Housing Act? Age, race, religion, sex, gender. The protected classes under the 1968 Federal Fair Housing Act are race, color, religion, national origin, sex, gender, familial status, and disability. Therefore, age is not specifically listed as a protected class under the Federal Fair Housing Act. While age discrimination is prohibited in certain contexts, such as employment, it is not explicitly included as a protected class under the Fair Housing Act. Who prepares the tax bill? Assessment Appeals Board. County tax assessors. The tax collector. The tax bill is typically prepared by the county tax assessors. County tax assessors are responsible for determining the assessed value of properties within their jurisdiction, which serves as the basis for calculating property taxes. They assess the value of properties and apply the applicable tax rates to determine the amount of taxes owed. Once the assessment process is completed, the tax assessors generate the tax bill, which includes the calculated amount of taxes owed by the property owner. The Assessment Appeals Board is a separate entity that handles property tax assessment appeals. They review and resolve disputes related to property assessments if property owners believe the assessed value is incorrect or unfair. The tax collector, on the other hand, is responsible for collecting the taxes owed as indicated on the tax bill. They send out the tax bills and receive payments from property owners. The transfer of rights under a contract without the release from obligation is known as an assignment. In an assignment, one party, assignor, transfers their rights and benefits under a contract to another party, assignee, while the assignor remains obligated to fulfill their contractual duties. The assignee steps into the shoes of the assignor and gains the right to receive the benefits and enforce the terms of the contract, but the original contractual obligations between the assignor and the other party to the contract remain unchanged. Which of the following is not appurtenant to real property? Deed of trust, mineral rights, easement, outbuildings. Among the options you provided, the one that is not appurtenant to real property is the deed of trust. A deed of trust is a legal document that serves as security for a loan on real property. It creates a lien on the property to secure the repayment of the loan. While a deed of trust is associated with real estate transactions, it is not considered an appurtenance to real property. Appurtenances are typically physical or tangible rights or improvements that are attached to or associated with real property. Mineral rights, easements, and outbuildings are examples of appurtenances to real property, since mineral rights refer to ownership or rights to exploit the minerals or mineral deposits beneath the surface of the property. Since easements are rights granted to others to use or access a portion of the property for a specific purpose, such as a right-of-way for a utility company. Since outbuildings are additional structures or improvements on the property, such as sheds, barns, or garages, which are considered appurtenant to the real property. Who is the borrower in the written promise to pay a debt? Payer, maker, lender, payee. The borrower in a written promise to pay a debt is referred to as the maker. The maker of the promise is the individual or entity who is obligated to repay the debt and signs the written agreement, commonly known as a promissory note. The maker promises to pay the specified amount of money to the lender or payee according to the terms outlined in the note. Therefore, in this context, the maker is the borrower. The laws that affect the licensing and conduct of real estate agents are called real property law, license law, agency law, real estate law. In California, the Department of Real Estate, DRE, has the real estate law, which includes statutes and regulations that real estate practitioners should be familiar with. Among the options provided, a mortgage is both a lien and an encumbrance on a property. A mortgage is a financial arrangement where a borrower obtains a loan from a lender to purchase or refinance a property. In this context, the mortgage serves as a lien, which is a legal claim or right that a creditor, the lender, has over the property as security for the debt. The lien gives the lender the right to foreclose on the property if the borrower fails to repay the loan as agreed. Additionally, a mortgage is considered an encumbrance because it places a financial obligation or burden on the property. The property serves as collateral for the loan, and until the mortgage is fully paid off, the borrower's ownership rights may be limited or subject to certain conditions set forth in the mortgage agreement. On the other hand, a deed restriction is a limitation or condition imposed on the use or development of a property, typically recorded in the property's deed. While a deed restriction can restrict certain activities or uses of the property, it does not inherently create a lien or financial encumbrance like a mortgage does. Real property may be transferred or alienated by all of the following options listed except operation of law. Operation of law refers to the automatic transfer or acquisition of property rights without the need for explicit action or agreement between parties. It includes instances such as joint tenancy with right of survivorship or easements by necessity. Therefore, operation of law is a valid method of property transfer. On the other hand, the other options listed, public grant, inheritance, and private grant, are all valid means through which real property can be transferred or alienated. 1. Public grant. Real property can be transferred through a public grant, such as when the government grants land or property rights to individuals or organizations. 2. Inheritance. Real property can be transferred through inheritance when it passes to heirs or beneficiaries according to the provisions of a will or intestate succession laws. 3. Private grant. Real property can be transferred through a private grant, which occurs when an individual or entity voluntarily transfers their property rights to another party through a legally binding agreement, such as a deed or contract. In summary, real property can be transferred or alienated through public grant, inheritance, and private grant, but not by operation of law. The method of appraisal based on replacement cost, depreciation plus land value is known as the cost approach. The cost approach is one of the three primary methods used in real estate appraisal, alongside the income approach and the sales comparison approach. The cost approach estimates the value of a property by determining the cost to replace the property with a similar one, deducting any accrued depreciation, and then adding the value of the land. It is commonly used for unique or specialized properties where there may not be sufficient comparable sales data available. The income approach, on the other hand, is a method of appraisal that estimates the value of a property based on the income it generates, typically used for income-producing properties such as commercial buildings or rental properties. The assessment approach is not a commonly used term in real estate appraisal. It may refer to the process of determining property assessments for tax purposes, which can vary by jurisdiction. A comparative market analysis, CMA, is not an appraisal method but rather a tool used by real estate professionals to estimate a property's value by comparing it to similar properties that have recently sold in the area. ICMA is typically used to assist in setting a listing price for a property or to provide information for buyers and sellers in a real estate transaction. The primary purpose of the assessment role is to establish a tax base for a particular jurisdiction. ARB, ARB, assessment, role, base tax. The amount of tax each property owner must pay is typically calculated by the county tax assessors. Bulk transfer laws, also known as bulk sales laws or bulk transfer provisions, are legal regulations that govern the transfer of a significant portion or the entirety of a business's assets outside the ordinary course of business. These laws are designed to protect creditors of the selling business by ensuring that they are not left unpaid due to the sudden transfer of assets. The purpose of bulk transfer laws is to prevent businesses from secretly selling or disposing of their assets without notifying creditors, which could potentially hinder the ability of creditors to collect their debts. These laws require the seller to provide notice to creditors and comply with specific procedures before transferring the assets.